Good evening, I'm Barkadat, here with the Mojo story. We are turning our attention today to the rape case at IIT-Guwhati that has its students, its alumni, and in fact, men and women across the country up in arms. Let's bring up our big story today around the verdict that has everybody so angry. This happened after a rape accused, a student at IIT-Guwhati, was allowed to walk out on bail. More worryingly, in fact, most worryingly, the judge, while decreeing the bail order, argued that both the accused and the survivor were future assets of the state. The accused lawyer was able to focus on his academic prowess and build a case for the judge to deliver in favor of a bail. But why should a rape accused be described as a future asset of the state or the country? The survivor, meanwhile, a young woman, has told Mojo Story that she feels slut-shamed, she feels sidelined, she feels discriminated against, and she feels fearful. This is what happens to so many women who actually follow the legal process while fighting rape, sexual harassment, and abuse. On the program today, we'll be looking at everything that we believe is wrong with the IIT Guwhati rape judgment, the bail, by the way. And what is important to mention at this time is that the judge, while ruling in favor of bail, also said that there was a strong prima facie case built out against the accused. So it wasn't as if the judge was not convinced about the prosecution's case. Let's introduce our guests on the program today to look at why our legal system responds in this way to rape cases. We're joined first on the program by Justice Anjana Prakash. She has been with the Patna High Court. Welcome to the program, ma'am. Abha Singh, activist and lawyer, is with us as well. Also on the program, speaking out about what's happened to her client, the survivor in this case. Let's welcome to the program Sumita Sarma. She has been representing, as I said, the survivor. I prefer to use the word survivor and not victim. And we're also joined on the program by Ashok Arora. He's an advocate and has also been with the Supreme Court Bar Association. Should be able to talk a little bit about the entrenched problems that we face in the judiciary when it comes to cases of sexual violence. I'd like to start with you, Sumitra. Your client, the survivor in this case, has given a detailed statement to us, and she has spoken about feeling slut-shamed, about feeling, discriminated against, about her mental health, about needing to get off social media. Can you tell us a little bit about what she's going through? Because I think it's very important, because we protect the identity, of course, of women who make these charges, but it's important for our audience and for the country to understand that we're talking about a very young woman, we're talking about a student, and we're talking about someone who's going through trauma right now, and more so after the accused in this case has got bail. Can you talk a little bit about her mental condition right now, ma'am?
She is a piece of rock to my mind, in fact, a diamond to my mind, and she has come out of this very strong. And but what has happened to her is slut-shaming. The accused influencing his peers. And in fact, the ambulance was not called. The ambulance was not called till the last moment. Somebody, one of his classmates who were there at the scene of crime, after the crime happened, had the brainwave to call her roommate, the survivor's roommate. And the roommate arrived, and the roommate immediately called the ambulance, much to the fact that they did not, in the face of the fact that they did not want the ambulance to be there.
So you're saying even an ambulance was obstructed to the young woman who has spoken out, saying that she was raped by a senior student. Can you just, for those who are coming into this case late, can you just go over the exact sequence of events as per the young lady that you are representing?
Knowledge. Yes. What had happened was there was a meeting of the Finance and Economics Club of the institution, the IITG. She had taken over, she had been selected as the secretary of that club for this year, for this year, and was taking over as one of the secretaries. There were about 6 secretaries. She was taking over as one from the erstwhile secretary the perpetrator of the crime. After the meeting was over, this was about 8:39 or so in the evening on the 28th of March. Then he said, I have a few things to discuss with you. Come along with me. Let us walk along this route to your hostel. She didn't have any fear because they in the IITs and all the top-notch institutions, males and females sit down together, work late into the night. So she went with him. He also told another thing that Mr. X is also going to be here, my classmate. Then she said she tried calling that Mr. X. Mr. X also didn't turn up. Nevertheless, she walked with him along that route. And he said, let's sit down here in an old school, dilapidated old school, and let us discuss. As they sat down, he started going inside the darkened school, that Akshara school, they call it. And used to go in back and forth. And then one occasion he said, why don't you come inside and see? She said, what is there to see? There is darkness. Then she went on turning on her mobile phone. And then suddenly he pulls out a bottle of alcohol and says, do you drink? She says, no. He shoves that alcohol into her, renders her unconscious. The medical reports are clearly indicative of rape on her. After she was rendered unconscious, she was raped. And then left to die.
Does he use the alcohol bottle as a way to violate her?
That we wouldn't know, because the materials on record point towards a half-open packet of Durex condoms in his hostel room. So and
we're talking about a 19-year-old here, right?
Yes, a kid. Yes, a small kid.
Yeah, technically, you know, an adult, but my God, if I remember when I was 19 and a college student, you know, I can only imagine her vulnerability.
Naive.
Yeah. I'll come back to the case and what happened with the ambulance. I just want to get Anjana Prakash, ma'am, who's been a judge herself. Ma'am, are you disillusioned with this comment by your fellow judge? I know you're a big stickler for the textbook, for the word of the law. We've done interviews before where you've underlined that. But what is the need for a judge to say about a rape accused? He's a future asset of the country, right? What is the need for this kind of comment, which is said in juxtaposition to there being a strong prima facie case? Please make sense of this for us.
Barkha, I was, I practiced on the criminal side for about 27 years, okay? And I was mainly a defense lawyer. And thereafter, I became a judge because of my, pre-criminal jurisprudence background. I was made to sit mainly on the criminal side. So I can tell you from experience, and whatever little law that I know about criminal law, that I know, that actually, what we are seeing right now is this, that, everywhere there is this, these headlines that the judgment is unfair. First of all, I must correct this. It's not actually a judgment. It's an order. A judgment is only after evaluation of trial, after the end of trial, when the judgment comes, on a return of verdict of guilty or of innocence, that is called a judgment. So this is merely an order. And as, according to the procedurally, this is an interim arrangement and not a verdict of guilt. So, since as an interim...
or not a verdict of guilt or of innocence, it must be said.
No, nothing. No, 1 minute.
Yes.
That's a very nice question that you've asked, about the verdict of innocence. Actually, our criminal law is based on the principle of presumption of innocence. So till such time as, there is a return, there's a big verdict of guilt, a person is expected, to be presumed innocent, and therefore the entire exercise of law, one minute, just 1 minute. So because of that, the trial has, you have to go through this trial. Now the point is, we are pointing out that the judgment says that even though the judge has granted bail, even though prima facie a case is made out. A prima facie, every case is made out and yet bail is granted because that is an interim arrangement. And as a principle of law, let me tell you that actually law favors, liberty rather than detention. And they say, you have to be liberal. So I'm not, on this, that what he has said, the merits of the case is important. Of course,
But what he has said cannot be removed. Now,
exactly.
can I just
1 minute.
can I just argue this from the perspective of the complainant, ma'am, with respect, from the perspective of a 19-year-old complainant who's a college student for whom it has taken a whole lot of courage to go to court, right?
Absolutely.
Against a senior, where college kids can gang up against you, to have the judge virtually hand out a character certificate describing this alleged perpetrator as a future asset of the country. Does this not demoralize?
Both of them.
Yes, so he draws an equivalence between them.
He describes both of them as future assets. That is irrelevant. I mean, according to me, maybe he stated too much. He need not have said that, He need not have said that. He could have said, that they are students and therefore there is no purpose, because see, there are other considerations that he's taken into, while granting bail. One is this, that the charge sheet has been submitted. Usually when the charge sheet is submitted, there is no question of, any additional material that can be stopped, by the accused person. There cannot be any tampering. So once the investigation is complete, there is no purpose of keeping the person behind bars. This is also one of the reasonings. And these two reasonings are perfectly sound, I think.
Okay, but you do agree that he need not have made the comment in open court about future assets?
Because of the type of crime that he's been, accused of. Because of the type of crime. Because I mean, like, if you look at it like this, future asset. If you look at it, from the moral standpoint, obviously, he may be brilliant. He may have, got into the IIT, which is obviously a very premier institute, because of his academic excellence. So that is one thing. But there is a moral aspect also of a human being, and that, to say then that future asset. In what sense are you talking about? Are you talking about only academic excellence, or are you talking about, the other aspect of a human being, which is extremely important, if not more important, than the academic intent?
So you are separating, and I need to get the reactions of the other panelists now. You are separating the order from the observations made by the judge, and you're saying the judge need not have made these observations. And let me get reactions. Poonam Muttreja is with us, Ashok Arora is with us, Abha Singh is with us. Abha, I'll start with you, then Poonam, then Ashok ji. Abha, go ahead. I can't help noticing the irony that so many of our other accused, we had an 80-year-old Stan Swami in jail without bail, and you have a 21-year-old here, who's not just granted bail, but he's given a slight pat on the back, ki chalo bachche, as if this is like some minor sort of crime. How do you feel, and how do you see this, both as a lawyer and as a feminist, Abha Singh?
The day I read in the newspaper, I was aghast. I was shocked, actually, that how can a rapist, and that to a student from IIT from whom you have great aspirations. In fact, I would say setting him free on bail would destroy the case totally. Even today, the conviction in rape cases is barely 29%. That is what the NCRB figures say. So here you have an intelligent IIT student who has raped a woman, and now he's out. Even if the charge sheet is submitted, even if though the charges are framed, he, as the victim says that she's being slut-shamed, he would demoralize her. So many victims turn hostile when the trial comes up for hearing. So this clearly shows that he being on the run is going to damage the case, and that is why conviction rate is so low. Secondly, the judge saying that he is an asset, I don't agree with at all. I would like the Supreme Court to strike down this statement, because it is demoralizing. A rapist cannot be an asset to the country, even if he is from the IIT or if he is from the IS. A rapist is a rapist. The law is very clear on that, and the sections are so strong. You talk of life imprisonment, you talk of such strong punishment, and when an educated person like him is committing such a heinous offense, why do we have death penalty? We have death penalty because it gives.
I've lost you, Abha. Can you hear me? Have you lost Abha?
I can hear you.
Yeah, I think your connection is a bit loose, so let us allow you to fix your connection. But I got the gist of your argument in the beginning, which was that you're aghast at this, and I want Poonam to add her perspective, and we'll just reconnect with Abha in the meantime on a better line. Poonam, go ahead.
So a rape is a rape, and irrespective of the identity of the perpetrator and age or anything, what is the, apart from the fact that it is absolutely unacceptable, and how can he be an asset? He's a danger, but to society and to women. But the real point is, what is the message the judgment is sending by saying he's an asset, or for whatever reason? So judiciary, we really have to look at the viewpoints and the regressive norms in society that not only impact an average citizen in this country, but society as a whole. And we've got into this business of making exceptions. How can we make an exception, especially the judiciary, which is looking at something they understand? So all I can say is that our social norms are becoming more rigorous. If this is where the judiciary is, think of the rest of the people. And our penal laws handed down have by and large remained untouched over 73 years of independence. But the English laws have changed. And I just think that there has to be, Abha's a lawyer, and she said Supreme Court should take notice. But I am surprised that every Indian has not expressed their disgust, their disagreement, their protest. This is something which nobody, but I have to tell you, Barkha, that there is a statement by IIT students from Hyderabad. And, when they called me to share their statement, they said never have they made a statement on any social issue so far. They are disturbed, they are disgusted, and they think, their statement ends by saying no campus is then safe and no woman is safe in the country if we not only have rapes happening, but more than that, the judiciary. I don't care whether it's an order or a judgment. To me, it's the statement has completely disgusting, demoralizing, and will send a wrong message. So how
I agree with you. I actually agree with you. But we were playing these slides of other commentaries by other judges in rape cases, and Justice Anjana Prakash knows that there was a judgment that came from Maharashtra where the Supreme Court did intervene, and that particular judge's sort of confirmation was then stopped. She was not allowed to, in fact, climb up the ladder. Ashok ji, how do you see this? This is not a conversation only for women, to be had by women, for women, about women. This is a conversation that concerns men and women, and it should not matter whether the judge in question is male or female. That is the other important thing. The law must speak for itself. The judges must be sensitized. How do you see this judgment, Ashok ji? This order, I should say order. How do you see it, Ashok ji?
Barkha, this is absolute shocking. In my career of dealing with criminal matters for last more than 4 decades, I have never seen such a bad order. And it reminds me, there's nothing about bad CRPC or IPC or system. It is more to do with the mindset of the judge. I've been talking about this. Many judges have talked about this. This training of mind is most important, which is not being actually provided to many judges here. A judge saying this, I'm sorry, I beg to differ with Anjana Prakash, that if charge sheet is filed, these are the reasons for ordinary crime, simple crime, not rape. There is a minimum punishment 7 years. It is life. In these cases, rule is jail, rule is not bail. Bail is not to be granted unless there is a prima facie case that it is false. Here the judge is saying that prima facie case is there. And if IITian student and saying that he is an asset, he is a future criminal. If you see that this is the case, you say there is a strong prima facie case, then he is a future convict. That is why in these cases, unless there is a reasons to believe or unless there is a ground that this is prima facie false, although the judge is not to record that it is prima facie false, but the judge may grant bail, taking into consideration all these circumstances, I grant bail. But saying this, it reminds me in fact of Oscar Wilde, who says nothing worth learning can be taught. So what was worth learning, I am sorry, this judge has not learned. Oscar Wilde says,
so do you believe Ashok ji that the Supreme Court must step in as it did with
Let me tell you something very important. Supreme Court judgment, the judge should have kept in mind, where the Supreme Court says that rape offense is not only against the physical body of the girl or the survivor, it is against the soul. It is against the soul. If that is the law of the land, that the Supreme Court says rape is against the soul, attack on the soul, should the judge say this so casually is saying, so casually? It is shocking. It should be, I feel there should be a disciplinary action also. Somebody should report it to High Court that this man, this gentleman judge, you must see that whether he should continue or not. It has shaken the confidence of nation, of any man.
Okay, thank you for that passionate intervention. Abha, I'll just let you complete your point, because you were also making the point that the Supreme Court must step in, and we have a judge on our panel who doesn't actually agree. So a retired judge, of course, but has been a judge for a very long time. Abha, do you want to come in on that and complete your point?
In fact, Barkha, you would remember that judge who gave that order in POSCO, that Justice Pushpa Ganeriwala from Nagpur bench of Bombay High Court, who said that no offence was committed because it was
skin to skin contact.
It was not skin to skin, and the child's breasts were touched through the dress. So that was what Supreme Court struck down. And I think in this also Supreme Court needs to come into, because you cannot idolize a rapist. He may be from IIT, but a crime is a crime, and you have to be very stern on this, because why do we talk of harsh punishments? Why death penalty was brought in after Nirbhaya case, if you remember? Because it said that when punishment is so less and few, you need to make a demonstration out of it. But here, if you are just praising him, saying that he's a future asset, then you are trivializing rape. I would say that, and this is necessary that this order is struck down. And the judges, I feel all the judges in India need to go for a training. In fact, when you have the posh law, sexual harassment at workplace, do you think this guy who becomes an engineer tomorrow, runs a company, he would be sensitive towards these laws? No, he would break them with impunity.
Yeah. So both Ashok and Abha think that the Supreme Court must take suo moto note of this. Poonam, I think you've made a very important point. Why is there not more national discussion, anger, rage? I think of this 19-year-old and I can't imagine what she's going through. Sumita, I want to come back to you, and then I'll come back to Anjana, Prakash. Tell us a little bit about what happens. You describe that this boy and she go for a walk. He's drunk. She
didn't know that he was drunk. He went in, sat down on the steps of that school. He then goes in and out of the room in the school. And then he says, come in once. So she asked him, what are you doing inside there? Come in once, Then she goes in and he asks her, do you drink alcohol? She says, no, I don't drink alcohol. He shoves the contents of the bottle into her mouth. She is rendered unconscious. And that comes in, the FSL report confirms alcohol. And then the materials point towards his packet of Durex condoms. And of all these papers and everything, I had a word with one of the top doctors in the hospital where she was initially treated, the medical college hospital. This may not, the opinion of that the top doctor of that institute it may not be the handiwork of one man.
So there may be more students.
There may be,
or accomplices. Okay. What happens after that? You mentioned that the survivor has difficulty getting an ambulance and it's obstructed. Yes, what happens? Yeah, what happens after?
She's left to die by the perpetrator, and then he starts calling up his friends, and his friends, the other people at the scene of the crime, three men and one woman. They arrive at the scene of the crime. They don't call an ambulance either. Someone amongst them has the brainwave to call up the classmate of the hostel mate, the roommate of the survivor. That roommate turns up, and she immediately calls up she along with her friends. They come up and they call up the ambulance. The survivor is taken to the hospital on campus. She could not be revived. I'm told she arrived in the medical college hospital with 7 heartbeats a minute.
And you say she's left to die. Can you describe,
yes. The reason
If she
is this was to cover up the crime, basically. The perpetrator tried to cover it up. Then he got his classmates to cover it up. He did not allow them to call an ambulance. Even when this roommate of hers arrived, the roommate was also stopped, her friends, two male friends, because it was late in the night, about 1:30, 12:30, 1 o'clock in the night, intervening night of 28th and 29th March. And they were initially stopped from calling the ambulance.
I want to bring in, I know all of you want to react, it's very disturbing, but I'll just get Anjana, Prakash, because, you heard the lawyers, you heard the activists, people believe this is a case for disciplinary action, at the very least, to the Supreme Court to to jump in. Do you agree, ma'am?
See, the thing is, Barkha, we are talking about a High Court judge who's granted him bail. Are we talking about a High Court judge who's granted him bail?
Yes.
If a High Court judge has granted him bail, there's no question of any disciplinary action against him. There cannot be any disciplinary action against him. He holds a constitutional provision. There is, the Constitution provides a manner in which a judge can be proceeded against. So I mean, like, there cannot be any.
But his words can be struck down.
One minute.
Can be struck down.
No, see, every order that a judge, as we all know, that our system is hierarchical, so what happens is if anybody is aggrieved with the High Court order, you can file an appeal before the Supreme Court, and the Supreme Court will pass a corrective order. So many times it happens, that the Supreme Court also says that maybe the reasons for this order may have been wrong, but the ultimate end, the order was correct. This is also a fact, the practical aspect of it is also true, that this is also how the Supreme Court rules or the High Court rules, that the reasoning may have been wrong, but the ultimate, the end result is fine.
But ma'am, the Supreme Court did strike down Justice Pushpa's words on the skin-to-skin contact, not being a prerequisite for it being abused.
See, that is what I'm saying. So when you file an appeal, the High Court can strike down when there is, a definite provision, which the judge has overlooked. There, in that case, if you see, the skin-to-skin, that was not the requirement, but the judge ruled like that, and she acquitted the accused. See, there is a difference. Here, it is an interim, arrangement. There it was a question of, giving a verdict of innocence. There, it makes a huge difference there. And that is why
hold on. Okay, ma'am.
That is what I'm saying. No. Okay. And the other thing that I want to say is, 1 minute. The other thing that you were asking, that how do you think, that the judge in a case of Mr. Arora was raising a question, that in bail cases, you cannot grant him bail and all. Murder cases has even more severe sentences, or maybe the same sentences. Dacoity with murder also. In that also, where bail is concerned, there is no separate rule as such, where bail is concerned. Okay, for grant or refusal of bail, or for judgment of acquittal of admission. One minute. In cases of POXO, yes. In cases of child, where the victim is a child, the yardstick is completely different. But where it's an adult, the law is the same.
But after the Justice Verma Commission and the changes in the rape guidelines, heinous cases, especially of gang rapes, if I remember correctly, are not bailable offences. Am I wrong? Somebody who knows.
No, you're not wrong. You're not wrong. Rape was never a bailable offence. Let me tell you.
Exactly.
No. But just because it is not a non-bailable offence doesn't mean that you cannot grant. You cannot be granted bail. Let's not confuse. See. When we are talking about something legally, let's understand the legal procedure. So before we attack it, just because an offence is non-bailable, doesn't mean that you will not get bail.
I understand.
That is what I'm saying.
I understand that non-bailable simply means you can still you can pick up somebody and not there's a procedural
without a warrant. Without a warrant, you can arrest a person without a warrant, and the magistrate will not grant you bail. The person will be granted bail by the session judge, the High Court, the Supreme Court, but the magistrate will not be granted.
Okay. Let's get responses. Okay, Ashok, Arora, go ahead. Please respond. Then Abha, then Poonam. Yes, Ashok ji.
Let me remind every participant, including Anjana, Prakash ji, I never said bail cannot be granted. I said normally bail is not granted. Then bail is not rule. Bail is not rule in case of rape. That I still repeat. And as far as disciplinary action goes, my lord, I mean, I still call you my lord. As far as disciplinary action is concerned, Justice Anjana Prakash, you are experienced enough. An order which shakes the confidence of the nation and the women in particular, or any conscience keeper, it is a good ground for the Chief Justice to refuse work, to withdraw judicial work. We know that it cannot be impeached immediately. But if you are to do justice to the system, immediately, if I was the chief, I would have withdrawn the judicial work. Okay, you sit at home or sit at your home, wherever. Oh, this is so shocking.
Arora, a lot of judges will say, thank God that you're not the Chief Justice.
This is a case for withdrawal of judicial.
In a lighter tone.
Let's come back to what can happen now. You see, what worries me, Poonam and then Abha, is that this discourages women from going to court. This is the kind of commentary. With respect to you, Anjana Prakashji, it has real consequences for young women for whom this is already a mammoth fight. The Me Too movement was born from the failure of the legal system to provide justice to women. And we have to understand that these casual comments that, the accused and the survivor are both future assets, it treats them at par. That's what I'd be feeling if I was this 19-year-old. Poonam, go ahead.
It's unfortunate. Yeah. There's no doubt. Yeah. It's unfortunate, okay. Barkha. It's unfortunate.
Thanks, ma'am. Let me get responses. Poonam Muttreja and then Abha Singh. Poonam, go ahead.
Barkha, it not only will discourage girls from reporting, women and girls, but it'll encourage worse or equally awful is the fact that it'll encourage men to rape and get away with impunity, the way it's happened here. And second, there will be a situation in India that unfortunately, other judges, we have a retired judge here almost supporting at least the order. I also question, I have serious problems with the order, not only on account of rape, Barkha, but it is, I'm not going to say attempt to murder, but what did he do to her by preventing her from getting treatment or being taken to the hospital? What the lawyers should tell us, what act against him can be slapped against him? It is not only the heinous rape, it is also he has tried to obstruct her from, risk her life. He has obstructed. There is an obstruction of justice to her already when he stops his friends and then her friends from taking her to a hospital. What about forcing alcohol into her, whether it was done by 2 people, 3 people, or 1 person? So this raises a whole host of things. And if the judgment or the judiciary system cannot do something to penalize, if I may use the word, this judge, then society should get up. And there are 2 issues here. There is the rape issue, and then there is the order issue, the wrong order. And I think that it is, the IITians have started, and I hope IITs across the country will take the lead. They are stunned, many of the IITians. Yeah. And I think it'll be great if men lead this movement to try and, along with us women, but they lead this movement. And I'm very happy to see the response from Ashok ji, but I cannot understand, Anjana ji, I have a lot of respect for you. I do not understand. I am not understanding and being able to accept what you say.
Before she reacts, I want Abha to add to it, and then Anjana can react, and we do have to close. Abha, go ahead. Abha.
Barkha, if you remember in the Nirbhaya rape case, the juvenile, because one juvenile was let scot-free, there was a change in the juvenile law, and it said that even if a young child between 16 to 18 commits a heinous offense of murder or rape, he would be tried under the IPC. So heinous offense has been treated, this murder and rape, and I think letting him go off. In fact, as we talked of Stan Swami or we talk of Sudha Bharadwaj, what charges are they facing? I think they are not that even strong, but they have been denied bail again again and again. Pregnant Safura Zargar was denied bail again and again. But here, because he's from IIT, you just give him a bail. That itself sets a wrong precedent. And of course, bail, not jail, is what the Supreme Court has said time and again. And only reason the court says bail should not be given is that if you tamper with evidence. And the very fact that he did not let the ambulance be called, the very fact that he took alcohol and got her drunk, tomorrow at the time of trial, he would say she was drunk and she gave consent. And he would get evidence for that. And that is why there is such a poor level of conviction. Yeah. So that point had to be kept in mind.
I think it's a classic case. Well, I'm using the phrase loosely because she did not consent to go out on a date with him, but what in the West is called date rape, where young women, against their will, against their consent, first their drinks are spiked. Sometimes, they don't even know that they're having alcohol. There's all kinds of ways to actually tamper with the consent here. Before I come to Anjana, I do want Sumitra, I know you're trying to come in. Is there a basis for you to believe that this accused out on bail is either powerfully connected or has influence on campus or is able to do something with the evidence? Can you speak to that, Sumitra?
Yes, he will influence his peers. He will influence the witnesses because his mother has threatened the father of the survivor earlier, and all these people. Let us ask ourselves, why didn't they call the ambulance? Because this man forced them not to. And why did they not call the ambulance? To cover up his crime. And the Honorable Supreme Court has clearly stated in the Anwari Begum case, Justice Pasayat's judgment, that there must be reasons in the order. Charge sheet or no charge sheet, there must be reasons in the order why bail is being granted. And the nature and the accusation, nature of the accusation, severity of punishment. Punishment is minimum 10 years now after the Criminal Law Amendment Act 2018. And then secondly, reasonable apprehension of tampering with evidence. Third, prima facie satisfaction, that is already there. Any order, Honorable Justice Pasayat says in that judgment, the Anwari Begum judgment, any order dehouse of such reasons suffers from non-application of fine.
Yeah. Anjana ji, you believe the order to be sound on law, but not on rhetoric. But that rhetoric has very real consequences because it is treating the crime of rape as if it were a minor adolescent rites of passage. You see, when you describe an accused as a future asset, along with the survivor, you are trivializing the magnitude of the crime itself. That is my very big problem with the judge's comment. Anjana?
Absolutely, Barkha. And actually, Poonam ji, what I wanted to clarify is this, that I was only talking about the position in law. I'm not either defending or, attacking the High Court order. So where the stray sentence is concerned, that about the future assets, etc. Of course, I always say, that there has to be, a moral obligation of every citizen. Until such time that is fulfilled, the person can never be called to be respectable. So how can a person who's even supposedly committed a crime like that, because as we know in service matters also, Abha, you must be knowing that moral turpitude is a big thing. That if there is, a conviction or of moral turpitude, then, your pension, etc., everything will be stopped. Here, it is a case of moral turpitude. So therefore, you cannot call a person who's accused of rape to be a future, to be a future asset. Now, the point is, whether he should have granted bail or should not have granted bail. That is, a discretion of the High Court judge. If he thought he could grant bail because of other reasons, such as charge sheet having been submitted and there was no use of keeping this person behind bars, etc., that is the usual thing. Let me tell you, this is the usual thing. It may seem, atrocious to a person who's not used to, the day in and day out procedural law, but this is the norm. Let me tell you this. Accept it. This is the fact. This is the fact. And if it was not so, you don't know how many under trials there would be, behind the bars. There would be, only under trials. And there would be, and because of this reason, the trial is not protracted for this reason, because there is so much of, out cry about, bail having been granted or refused, that the focus shifts only to bail. And I am a big advocate, of this, that people should stop focusing on bail. Please talk about trial. Let there be a trial. Let there be, a verdict of conviction of, of guilt.
Let's get responses to this. We have literally a minute left, so 30 seconds each to Ashok, Abha, and Poonam. Ashok ji, we'll start with you.
Two things, Barkha. Number one, his mother also should be booked for threatening the witness. And number two, very serious thing, since they stopped the ambulance, all those boys or girls who stopped the ambulance should be booked under 307 attempt to murder. Because if the heartbeat was so low, so that means definitely she could die. If you stop the ambulance, stopping ambulance, actually it means here that they should be all booked, and including the mother who threatened. And if you threaten the witness, it is a good ground to refuse him bail till the end of the trial. Thank you.
Abha.
The witness, this is a very good ground for bail to be cancelled. I think immediately they should move the Supreme Court and get this bail cancelled. Also, I would say, because he's from IIT, I would say he has that much of the brains, he would definitely ensure that the conviction does not take place. He would weaken the case. His being out will damage the case, and that is why more than 50% of the rapists go scot-free in this country. Hence, it is necessary. And there are innumerable cases where the courts have said that you can be behind bars for at least half of the punishment. And in rape, minimum punishment would be 10 years. So at least 5 years he could have been in jail before being granted bail.
All right, Poonam, now what I don't know, and Sumita was just telling us, the family has not yet decided, is whether the family will appeal against this order. The family might be very demoralized at this point. The family might be scared at this point. And we have to appreciate that, and which is why I believe that even without that appeal, there should be something forthcoming from the Supreme Court. Your last word, Poonam Muttreja.
But shouldn't there be a suo motu case or civil society? Yes, the family must be very disturbed. In fact, I was thinking of what is the kind of support the girl can get and her family. But one thing we certainly can do is civil society should take the job and the responsibility of going to Supreme Court for cancelling the bail. I'm absolutely with the others. And also, now that I know, I was wondering if he can be tried for attempt to murder. He should be tried for attempt to murder, so that let's hope that no rapes, but in cases of this, in cases of rapes, we know there are other instances.
307 has been slapped on him.
It has been slapped on him, as it should. Absolutely, it should be.
Good.
I have to say, Barkha, as a woman, I felt really humiliated. My heart goes out to the victim, but even as a non-victim, a woman who's used to so many cases and dealing with these issues, I felt really angry and insulted and humiliated.
Yeah, it is both a trivialization of rape and an obstruction kind of, red flag to others like this young girl who may want to, approach the courts for justice. And that is the real problem with it. And I do hope that there's more outrage and more attention on this case than there has been. Please think of a 19-year-old fighting this fight, what it would have taken her to go to court to begin with, and what she might be feeling today about being juxtaposed with her perpetrator, like they're both cut from the same cloth. That is essentially what the judge has suggested, while ironically saying in the same order that there is a prima facie case against him. It just boggles the mind. We leave it there to our panel. We'll continue to follow this story. Thank you for your insights and wisdom today. And to our audience, see you tomorrow, same time, same place. Thank you for watching.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.